Reitumetse Phiri joins us now to weigh in on the developments in this case. Reitumetse, thank you so much for your time. Good afternoon. Look, let's first understand the legal basis and grounds that the IEC is taking this matter on appeal. And do you think they have a substantive case, you think?
Yeah, I mean, I think, in the absence of the reasons from the IEC, we don't know exactly which part of the reasoning the IEC would be challenging, but certainly the order is incorrect. And I think they have a basis to challenge it because Section 47 of the Constitution is very clear that if you have been convicted of a crime for more than 12 months without the option of a fine and sentenced to for more than 12 months without the option of a fine, you cannot run for the National Assembly. You're ineligible to be a member of the National Assembly unless you've sat out for a period of 5 years as sort of a cooling off period. But you may contest any other office. It's just the National Assembly that we're concerned about when we're talking about Section 47. So I think the IEC has good grounds of appeal. Well, obviously, they'll flesh them out more once the reasons come out. But my view is that the order is incorrect the way we've actually seen it.
Reitumetse, this is the issue. I mean, it gets really tricky, right, on the issue of the sentence served versus the remission as well as its ramifications, right? And I think this is where we saw even the presiding panel of judges also trying to ascertain this point. So was the Electoral Court right then in its findings to allow Zuma back on the ballot based on those arguments?
I don't think it was correct. Because either way, if you take the president's remittal as reducing the time of incarceration for Mr. Zuma, which is really what happened, and not so much the fact of him being convicted for 15 months imprisonment. I think as far as the courts are concerned, which are the constitutional body that grants court orders, Mr. Zuma was convicted of an offense for more than 15 months. And the remittal, I don't think has it doesn't adjust that position. Yet it may have adjusted how long he was in prison for, but it actually doesn't adjust what is the actual factual position that he was convicted for that period. And for that reason, he shouldn't have been able to contest for the National Assembly.
And the argument here then, Reitumetse, is that, I mean, of course, the Constitutional Court was the one that initially handed down the sentence. And for the first time, this is the argument, right? For the first time, we saw a Constitutional Court handing out a jail term without even that option of appeal. So this is what, of course, Dalimpofu, as well as the representatives of the Umkhonto weSizwe Party were arguing that. So how does this section then apply to the fact that, first of all, Mr. Zuma was actually sentenced without the proper conditions that one would be processed through the court system?
So, I mean, for the section insofar as it applies to appeals, it only extends the period from which your conviction starts. So, for the period that you are appealing any conviction, you may contest for a position in the National Assembly. It's only when that appeal becomes final that, you being disqualified starts to run that period of 5 years. So, from my perspective, it doesn't make a difference, the fact that the Constitutional Court made that decision without the option of an appeal, because had there been an appeal, it would have started running from the moment the Constitutional Court presided over the matter anyway. So, it's really not a big point as far as I see it. The fact that, he was found guilty of contempt of court and sentenced on that basis by the Constitutional Court.
And then why the Concord, do you think, Reitumetse? Could this appeal not have been applied for under a different court?
I think the Concord is the right place to go because it is a constitutional question. It is Section 47 of the Constitution. And I think, one of the arguments will be, how does it interplay with Section 19, the right to run for political office. I think this may be one of the issues that requires, interpretation and guidance from the Constitutional Court as to how we actually read these provisions in the Constitution in a way that they hang together. Because I think as it stands, it seems like Section 19 may be diametrically at odds with Section 47 at the moment, at least from what we're seeing from the Electoral Court. But I think it would be important for the Constitutional Court to direct how those two provisions must sit together and what we are to make of people that run for the National Assembly with criminal records or who fall into Section 47.
And very quickly, Reitumetse, look, I mean, let's look at the history, right, between the current Chief Justice Raymond Zondo as well as President Zuma. I mean, how do you, envisage this whole case is actually going to turn out? Might we see a recusal or a request for even a recusal? And looking also at the time, we are less than 2 months away from the elections. Do you think that the ruling could actually be handed down before we go to the polls?
I think, what has been quite commendable is that these electoral matters that we've seen that have involved the IEC and MK and the ANC, they've been dealt with on an exceptionally urgent basis in accordance with what the Act dictates, because, these matters must be dealt with on an urgent basis. It's good to see that the IEC noted their intention to appeal quite quickly after the order was handed down. And I would hope that the Constitutional Court will deal with the matter with the requisite urgency. I think the courts so far that have dealt with each of these matters have been alive to the urgency and the need for the matter to be dealt with swiftly ahead of the election. Insofar as Chief Justice Zondo is concerned, we're not sure what the composition of that Constitutional Court will be, whether they actually will hear the application from, or at least the application for leave to appeal to the Constitutional Court. I think they will. I think the interests of justice dictate, and I think the question that is in front of the Constitutional Court will mean that the Constitutional Court will hear the matter, and then we'll just have to see who's on the bench when the matter gets heard at the Concourt.
Certainly one to keep our eyes very tightly peeled upon. Thank you so much, Reitumetse Phiri, the legal analyst, with analysis on the IEC taking the Electoral Court's decision on Zuma being on the ballot now to the Constitutional Court.